you take case laws or in that under that particular statute to the courts, more you will see that courts will shape uh, the destiny of that particular statute with the help of judicial judicial decision. So at no point you will realize that you at no point in common law system you would realize that you will realize that you cannot move away from the importance that judicial decisions enjoy in common law tradition. So today we are starting our discussion from this point. It states that civil law principles, which are frozen into courts and often rigid doctrines, are in a way imposed on courts. So once again, we will pick up the thread from our discussion on doctrine of stare decisis and from the fact that courts are the core of the system. So in civil, if a legal system, if a country's legal system is based on civil law tradition, then what you will see there that the legal principles are contained in courts in the form of very rigid doctrine. Why rigid doctrine? Because no organ of the government has been given the power to read and interpret the words and expressions of a legislation in a manner which could make them flexible or wider, or wherein you could say something that has not been provided in the code. So the idea in civil law system is that you are telling the court, in civil law system you are telling the court that look, this is the code and this is what you implement. Do not infuse your judicial mind into it. This is the code and you need to implement it. So it's like, for a common law lawyer, it is said that if suppose you land a common law practicing lawyer or a lawyer practicing in a common law jurisdiction, in a civil law jurisdiction, he would be taken aback. Or if you land a judge of a common law tradition in a civil law tradition, he will also be taken aback because he is now being treated as a mid-rung civil servant who is going to do what is being told to him. What is being told to him? Do this. And if he asks you why I am supposed to do this, because it is written here. So the task of a judge is to read and apply the code to the facts of a case. He cannot apply his or her judicial mind in civil law tradition to make any changes or to read the words of the statute otherwise. While on the other hand, in common law system, rules can be changed from time to time. Even when you have a rule contained in a statute in common law system, still you are not in such a position wherein you cannot make necessary changes to that particular rule, because common law courts enjoys this power to interpret the statutory provision, and there is a separate paper for that, and we will study this topic of statutory interpretation with the help of few main rules of interpretation in this semester also, and these rules might help you in reading case laws in a better manner. So in common law system, judges enjoys this power to interpret the statute, and the higher the court, the wider is the power to interpret. So for example, the power which is being enjoyed by the Supreme Court and the High Courts, because these are the red courts in India, to interpret the provisions of a statute is much wider than the power of the lower courts, in the sense that if suppose there is a provision and you are required to apply that particular provision to decide a particular case law, and if you arrive at this particular conclusion as a judge that look, this provision is not drafted in a manner so that it could be applied to give such and such relief in this particular case, so you can insert your own ideas, own words or expression into the provision of that particular statute, or you can derive from that particular statute a different kind of a rule or some other rule which was not expressly laid down in that particular provision and accordingly decide the case. And your decision would now become an integral part of the studies relating to that particular provision. Whenever anyone would flip through the pages of that particular code and try to read a particular provision, he or she has to read that along with case law. And that's what you are doing in your other papers. For example, when you are reading Contract Act, you are reading it in the background of the case laws. When you are reading IPC, then you are reading it in the background of the case laws. Or if suppose there are no case laws, the act or some provision in the act has been introduced for the first time, there also you are substantiating your reading with the help of the case laws. You cannot complete your discussion or your reading of any statutory law in common law jurisdiction. For example, in this semester you are studying four other papers as well, and therein your source of study, main source is statute and case laws. So you cannot complete your study of in a particular subject in common law jurisdiction without referring to the case laws that have been decided by the courts under the legislation that you are referring to or that you are studying as a part of your semester paper. So civil law system, next point of difference, are closed in the sense that every possible factual situation is governed by a limited number of general principles. This is interesting, and try to understand it. I'll try to explain it to you. Now, when we are saying that, look, all the legal principles, for example, we take for that matter a law of contract in the civil law tradition. So the rules relating to law of contract are frozen into civil codes in a civil law tradition. Now, whether a civil law judge is confronted with a case having X facts, Y facts, Z facts, A facts, B facts, C fact, D facts, and the series goes on like this, whatever the facts of a case are, the judge has access to the principles contained in the code only. He cannot apply something else. So, for example, he cannot bring a concept like equity, justice, and good conscience. He cannot bring into bring for his assistance different rules of statutory interpretation, which would help him to tweak the language of the code a little bit and then accordingly apply to the facts of the case. So that is why it's a kind of it seems to be a closed system in the sense that every possible factual situation, every possible which you can fathom. So the situation in civil law system is that you enact a code, and after that, if you are getting case laws relating to a particular provision of that particular code, you have to apply that provision only in order to decide those factual situations. How complicated the facts of that case could be, how different the facts are from each other, you have only one source for your assistance to decide that particular case law, and that source is contained in the code. While on the other hand, common law system are considered to be open system, because judges like the master of the legal system. So suppose you are a judge in the common law system and you come across a case law wherein the facts are such which are not properly covered by the statutory provision. So accordingly, you can dig out some case which has already been decided, apply the principle from that particular case law. Or suppose there is no case law, therein you can apply your judicial mind and accordingly create a new principle, keeping in mind the facts and circumstances of the case. But normally this exercise wherein you end up introducing, or you are introducing a new idea or a new rule of law or principle in the law, is such power is generally being enjoyed by higher court judges in common law system. The lower court judges in common law system by and large are bound by the decided case laws and statutory provision both. In civil law system, whether you are a lower court judge or a higher court judge, you are bound by the code. You are bound by the court. But in common law system, if you are a judge of the higher court, then the power that you enjoy when you are sitting at the bench while deciding the case law is very wide. You cannot at all compare it with the judge in a civil law tradition. Judge in a civil law tradition behaves like a civil servant, like a bureaucrat, while the judge in a common law tradition is shaping the law. He is the guardian of the law. He or she is the guardian of the law. That is why civil law system are considered to be closed system and common law systems are considered to be open system, in the sense that new rules may be created or imported for new set of facts by judicial decisions. And that's what you do when you study contract act. When you study contract act, when you study your IPC or family law, you would realize that what is happening, that it is because in a particular case a new set of facts were before a particular bench, and they decided to come up with a new rule of law, or they decided to reject the already prevailing rule of law and replace it with a new rule of law, with a new rule of law that would be applicable or that can be used by the future judges to decide case laws accordingly. Now, next point is, and this I have already discussed with you, that the importance of procedural law, when you compare it with the importance that you give to substantive law, in civil law tradition, substantive law received more attention, and the situation is similar till now. So in civil law system, the focus of the judiciary is, and focus of the entire legal system is towards fortifying or towards making substantive law as clear as it is possible, as it is humanly possible. So their entire focus is on the substantive law. While on the other end, if you look at those legal systems which are wherein the main feature of the legal system is derived from common law tradition, therein procedural laws are also given considerable attention. You do give attention to the substantive law, but at the same time you give equal or comparable attention to the procedural laws. And it is because of this reason you would see that there is a elaborate evidence law, or there is an elaborate statute relating on law relating to evidence in India, and that statute is considered to be as important as substantive law at the time of the trial or during the trial. Similarly, when you will study CPC, you would realize that the civil procedure law is so comprehensive, and the rules of procedures are given such a huge importance in common law tradition that half of the time during the proceedings of a particular case, be it a case relating to contract tort or property law, half of the time it seems as if you are engaged with the procedural law only. So procedure is very elaborate in common law system. Some procedural principles are considered to be binding, and it is very formal. You cannot treat procedural law in common law system to be a branch of law which has nothing to do with the decision of a case. So a case, when it is being heard and decided by a court in common law system would give equal importance to both substantive law as well as procedural law. In common law, in civil law system, trials or proceedings of a case law are conducted in a very friendly manner. Why I am saying in a friendly manner? Because the judge and the counsel of both the parties, contesting parties, they try to act as a team with a common objective that we want to deliver justice in this particular case. But that is not the situation in common law system. And from this, we may come to the next point of difference, that the civil law tradition normally follows a inquisitorial idea of delivering justice by way of conducting trial. Now, in this inquisitorial idea, one thing I just told you, that why we say that it is inquisitorial civil law tradition, because while hearing and deciding a particular case, be it civil or criminal, the judge and lawyers representing both the parties, they are acting as a team. So judge is equally concerned in finding out or in establishing the facts of a case. Judge may investigate the matter, actively participate in the investigation. For example, judge may decide to go to the crime scene. I want to go and see the crime scene, how things happened, how the facts of this case unfolded, right from the very first day to the last day. So it's up to the judge. And the lawyers would assist the judge in this particular task. So that is why I said that they would act as a team. While on the other hand, the common law system functions as an adversarial system. Adversarial system means that the contesting parties to a case, they are considered to be adversaries to each other. So every case, be it civil or criminal, is a contest between two opposing parties, wherein judge sits as a moderator, or wherein the judge sits as an umpire. It does not mean that the judge would be a mute spectator. Sometimes people, when they discuss adversarial system, they simply mention this particular sentence and does not elaborate upon it. When we say the judge sits as an umpire, it does not mean that judge would sit there as a mute spectator. What does it mean then? It means that judge would not act as a team with the counsel of the opposing parties. Rather, judge would be there to hear both the sides in an unbiased manner, and accordingly decide that which side's argument are such which are able to sway his decision, or which arguments are such that the judge considers to be the correct arguments in that particular case, and accordingly decide the case. Now here there is an interesting element which you will not see in our legal system, or I would rather say that earlier we had a similar system in our legal system, but now we do not have since 1950s. So and I'll ask you to read more about it on your own. Now, and this is very important. Now here what is happening, that it is the judge's role to establish the facts of the case, investigate the matter, and decide the case. So in adversarial system also, it is the role of the judge to decide the case, but there is an additional element as well in common law system, and that is the existence of jury, or the existence of trial by jury in some common law countries. So if you suppose ask this question, that sir, in India nowadays we do not have trial by jury, so can we say we have drifted from the rigid model of common law tradition? We are no more a common law country as far as the method or mode of conducting trial is concerned? Then I would say that you are correct to a certain extent, because one of the most important feature of common law tradition is trial by jury, and you can call it to be having a similar importance as you give to case laws while deciding case laws. Case laws form the core of the system. So you may safely say that the second core of the system, or the outer or middle core of the system, is formed by this idea of trial by jury. And it is a very kind of a novel and and very different idea that could possibly be introduced in a legal system. Why? Because what you are doing in a trial by jury, you are picking up common people. You are picking up common people and making them the part of a jury, and that jury of 12 people would now going to decide the fate of an accused person who is on trial for committing a heinous offense. So normally the situation in current times is that if you have committed offense of certain characteristic in nature, which is punishable normally, which is punishable with higher sentence or higher punishment, or the serious offenses, their trial is conducted by jury. Trial is conducted by jury. So what you are doing by way of introducing this idea of trial by jury, you are relying on the intelligence or the rational mind of your own people and giving them the power to actually decide whether the accused person is guilty or not guilty. So in a common law system, trial by jury is also considered to be an integral part of the system. And if suppose you ask this question that in India we do not conduct trial by jury, then I would say that this is something that we are not doing as per the common law tradition. We have shifted more towards civil law tradition, wherein judge is exercising more and more power. But still, we are somewhere in the middle. We have a hybrid model. We do follow adversarial system, but without trial by jury. Our judge does not sit as an umpire most of the time, because the laws have been drafted in such a manner. As these are colonial statutes, most of the procedural law were introduced by or were created during the colonial times, and the judiciary during colonial times used to comprise of mainly English judges, and they has to maintain. So for them, law was a vehicle of continuing with their colonial structure. So law is not treated to be something through which you are going to deliver justice. Rather, Britishers considered law in India to be something with the help of which they can maintain and continue to maintain their power on Indian people, and continue to retain their power on India as their prestigious colony or as their prized possession. So that is why the kind of power that is being enjoyed by the judge conducting a trial, be it in a civil case or in a criminal case, is comprehensive. That is kind of not actually that is not similar to what the English judges themselves enjoy. So the judges in colonies used to enjoy more power because most of the judges or judiciary comprised of English gentlemen or English judges, and the objective of the law, or the judges were trained in such a manner to apply the law with this objective in mind, that we need to continue to retain power on this particular colony. So Indian system is adversarial as far as conduct of trial is concerned, but it lies somewhere in the middle. We do not conduct trial by jury, but at the same time we do give considerable power to the judge who is conducting the trial, and also the judge does not act as a team member of as a team with the counsel of the opposing parties. So in a trial by jury, I'll talk about it a little more. In a trial by jury, like, people are chosen, jury is chosen by the court with the help of the lawyers, and the lawyers could take objection as far as someone being chosen as a part of the jury. They can take objection that I do not want this person to sit on jury, and there are grounds of that particular objection. It depends on the system in which the trial by jury is being conducted. If it is being conducted in UK or USA, the rules may differ, but you can take objection as far as someone being a member of the jury, and accordingly that person can be replaced if your objection is sustained by the court. And once the trial starts, both the counsel representing the parties to the suit, that is prosecution and the accused person in a criminal case, and plaintiff and defendants counsel in a civil case, they will present their case before the jury. They will produce the relevant they will produce the witnesses and relevant evidences before the jury. And the task of the jury in a criminal case would be to decide whether the accused person, whether according to them the accused person is guilty or not guilty. And there are rules on if the jury is divided, then what will happen, and how many people you need to actually pronounce this particular thing that the accused person is guilty on. And once this verdict is pronounced by the jury, then sentence shall be pronounced by the judge based on that particular verdict. So the task of the jury is only to pronounce this verdict of guilty and not guilty. And the last point, just a second, I'll come back. Legal scholar is the central actor of shaping the law. This I have discussed with you. Here, judge is the central actor in shaping the law, and you can relate it with other point of differences. Juries are generally not part of the judicial system, and this I am repeating it in the sense because this difference was basically on inquisitorial system and adversarial system. So juries are not the part of judicial system in civil law tradition. Judge relies on professional investigation and lawyer's argument rather than leaving the decision on facts to the jury of 12 people. Juries are vital to common system, but that is not true as far as Indian legal system is concerned. But if you talk about the main features of a common law system, then trial by jury is one of the main feature of the common law system. And the idea is that jury is an attempt to democratize the system. Let the representative of the people decide who is guilty or not guilty. Lawyers are generally seen as academics and scholars in civil law system, and this point of difference is also pretty interesting as the point of difference that we discussed in the last slide, that judges are appointed, judges are first recruited into specialized schools, trained, and then they are appointed. While in common law system, in the higher echelons of judiciary, you make such individuals judges, or you appoint such individuals to hold the post of judges or justices who have been sufficiently trained at the bar. Here lawyers are generally seen as academic or scholars in civil law tradition, while in common law tradition lawyers are professionals. Why I am saying lawyers are professional? Anyone? I wrote that lawyers are professional like doctors and accountants.
Because they practice.
Because it's a rule.
Because in common law system, in most of the common law system, it's a regulated profession. Being a lawyer is a regulated profession. And for example, in India, it is regulated by Bar Council. And there is a act, Advocates Act,
Indian Advocates Act.
Indian Advocates Act. So that we will study. We will talk about that particular legislation also in one or two lectures, because that is also a topic in your syllabus, that students should know that through which law or by which law their profession is going to be regulated. Suppose if you decide to practice law. Now, English system is very interesting in this regard. Like, I'll take your 5 minutes, and this is outside the kind of outside of the box kind of information. In England, lawyers are divided into mainly two streams. You could either become a solicitor, or you could become a barrister. If you want to become a solicitor, now they have changed their rule. As on 2022, they have changed their rule. Now, in order to become a solicitor, you must be having a degree. You should be having a degree in law as per the new rules. Even if you do not have a degree in law, you can still appear in a SQE exam, solicitor qualification exam. I think they have applied that particular law. Please check on your Google website. Check on Google whether SQ exam has been introduced or not. Maybe they were supposed to introduce it in 2022. So for the purpose of writing that SQ exam, that is going to take place in 2 phases, SQ1 and SQ2. I think now you don't have to be a law graduate. So earlier you either you have to be a law graduate, or you must have completed a diploma, 1-year diploma that is being offered by some of the designated universities in UK. So the function or task of the solicitor is to solicit or to give advice to the clients. Solicitor cannot appear before the court. Solicitor cannot be appearing counsel. As suppose when you will become, in India there is only one stream of lawyers. You study law and then you register yourself with the respective bar councils of any of the state. You can register. For example, if you want to register yourself with the Delhi bar, you will register with the Delhi bar. If you want to register yourself with the UP bar, you will accordingly register yourself with the UP bar. And then in India you are required to appear in the All India Bar examination. And once you pass that particular examination, you will get a certificate of practice, and then you can perform both these functions. You can solicit the clients, you can give advice to your clients, and also appear before the courts in case laws representing your clients. But solicitor cannot do that. But certain changes have been made wherein some solicitors may be designated as solicitor advocates in England. So if you have been designated as solicitor advocate, then you can appear before the court in certain cases, mainly before the trial courts, criminal trial courts or civil trial courts. You may appear before, for example, you may appear before the magistrate's court, you may appear before the crown court conducting trial by jury. That you can do if you have been designated as solicitor advocate, and there are conditions for that. The second stream of lawyers in England are barristers. In order to be barristers, or in order to become a barrister, either you must be having a degree in law, or you must have completed a graduate diploma in law. That there is a one year course. After that, if you have completed, for example, if you have completed law, then you don't have to complete that graduate diploma. That graduate diploma is for non-lawyers or people from other jurisdictions. For example, if from India you want to go to UK and become a barrister, so first you will be required to complete a 1-year graduate diploma in law. Thereafter you are at the same position. So a person who is a law graduate and a person who has completed a graduate diploma in law, they are at the same position if they want to become barrister. The process from here would be same. And what is that process? You need to complete, first of all, you need to register yourself, or you need to become a member of and this is interesting. You may laugh on it, or some of you may laugh on it. First of all, you need to become a member if you want to become a barrister, and this is the procedure if you want to become a barrister. So first of all, you need to become a member of an inn. So there are 4 inns: Gray's Inn, Lincoln Inn, Middle Temple, and Inner Temple. There are four kind of, you can say these are the stables where horses are trained. You can compare it with that. For example, horses are trained in a particular country to run in a particular race in certain stables. So in England, the situation is that barristers, if you want to become a barrister, then you have to become member of any of these 4 inns. Once you become a member of these 3 inns, then you need to complete a training program, that is on-site training. So for the purpose of that training, earlier you used to participate in certain activities and attend 24 dinners. Now the number of dinners have been reduced to 12. You need to complete 12 dinners. And there is an entire structured process of completing that particular dinner in these four inns. And then you will be called to the bar. There will be a very, I have sent you a documentary. Therein the first scene of that particular documentary relates to that bar calling ceremony. Once you are called to the bar, then you need to apply for articleship before any of the chambers of these 4 inns. So each inn has chambers, and each chamber, जैसे इंडिया में होता है ना, that a lawyer has a chamber, इंग्लैंड में थोड़ा इससे डिफरेंट होता है. किसी लॉयर के नाम का चैम्बर नहीं होता, एक चैम्बर होता है फॉर एग्जांपल, और उसके अंडर में 20 से लेके 60 तक एडवोकेट्स हो सकते हैं, बैरिस्टर्स हो सकते हैं. So you, after being called to the bar, all the people who are called to the bar normally, for example, if 2000 people are called to the bar in the ceremony in a particular year, then all of them would apply to become for example, if all of them are applying to become the member of the chamber in all of these 4 inns. After this, for example, after being called to the bar, you can apply to become the member of a chamber in any of these four inns. So only 200 to 300 people would get lucky and would be called to be part of the chamber. Once you become the part of a chamber, you would remain to be part of that particular chamber throughout your life, and that is how because you have become barrister once you have been called to the bar. But till the time you do not become a member of a chamber, cases will not flow in your pocket. It is only when you have become the member of a chamber, which is normally comprised of 20 to 60 lawyers or barristers. It is only when cases would flow in your pocket or through your pocket, you will be able to earn something. And once you have become a member of a chamber, then you are safe. Because suppose if your chamber has 30 lawyers when you joined, now within a passage of 10 to 15 years, half of the lawyers would either die or would stop practicing. So you will become a senior member of your chamber. So all the solicitors who used to bring cases to your chamber would continue to bring cases to your chamber. So now when seniors are not there, you will be handling their cases. So the system is very democratic as well. ऐसा सिस्टम नहीं है that if your father is a lawyer, you can sit in his chamber. ऐसा सिस्टम है. The system is entirely different. So normally it is like jokingly said that in England lawyers are trained as horses are trained in certain specialized stables. Lawyers are trained in this manner, and all barristers are trained in London only, because all inns are there in London only, and all the main offices of all the chambers, the office space in all the chambers are also in London only, in these 4 inns. You may practice and you may travel to other areas also for the purpose of appearing, or you may sit in your you may make your office, but theoretically speaking, you will always be associated with the chamber. You will always be associated with the chamber when you are practicing as a barrister in England. In England. So and this is the last point, that discovery of evidence, not elaborate, because when you will practice law in a common law country, then the half of your focus, as I told you, would be on procedural law, because when you read Evidence Act, there are elaborate rules relating to discovery of the evidence, admissibility of the evidence, and your entire focus while studying Evidence Act would be on understanding which evidences are relevant, which evidences are relevant as well as admissible, which are not relevant, and half of the time during the trial, the court is also engaged with a similar task, that which evidences could be allowed to be produced, and which evidences, or in other language, which evidences could be made part of the record of the case, which evidences are inadmissible, which are admissible. Such is not the situation in civil law tradition, because you can produce any evidence before a civil law judge conducting a trial in a civil law system. He will accept all the evidences initially, and then he will decide which evidence he may use for the purpose of deciding the case. So you don't have to be trained in law relating to evidence in civil law tradition, but that is not the case with common law tradition. So that's all which I wanted to discuss with you on this particular aspect of the differences between civil law tradition and common law tradition. Now you can go ahead and ask anything.
Sure. I have a question, sir. As you mentioned, like the adversarial and inquisitorial system. सर जो पंचायत सिस्टम होती है उसमें इन्वेस्टिगेशन भी होती है और फिर अंपायर वाली भी होती है, तो
पंचायत
पंचायत
सिस्टम कहाँ
सिस्टम
से आया, मतलब?
सर वो भी तो एक फॉर्म ऑफ जुरी है ना, लाइक मतलब जो पहले के टाइम में ऐसा होता था कि वहां पे
हाँ,
केसेस जाते थे.
वो अभी रेलेवेंस नहीं है उसका. पंचायत सिस्टम डू नॉट इज नॉट कंसिडर्ड टू बी द पार्ट ऑफ अ लीगल सिस्टम इन कंटेम्पररी टाइम्स. Even in India
Okay.
also, na, you do not consider a panchayat system to be part of your formal judicial system. That is
Yeah, yeah, sir.
extrajudicial authority.
Yeah. So, sir, that is like both. It operates both methods. Like it operates adversarial and inquisitorial too. So, sir, like our system also operates like both adversarial and inquisitorial too, like common law and civil law.
नहीं 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 नहीं, मैंने यहाँ पे आपको बताया ना कि our system is adversarial, except this fact we do not conduct trial by jury.
Okay, sir.
Adversarial system simply means that the parties, the councils who are representing the parties, they are adversaries to each other. So they will be delivering opposing arguments, contesting arguments, and judge would not act as a team with those particular lawyers. Rather, judge will sit as an umpire or a moderator and would decide the case taking into account the arguments put forward by both the parties. हाँ जी, बोलिए बोलिए.
So, can you please explain the second point, the common law statutes have to be along with the red line?
This one?
Yes, second point.
So it's very simple. For example, in India, when you argue a case law, for example, then you would see, you would realize that you cannot argue your case law without citing you cannot argue a particular case without citing the case laws, relevant case laws. So that is not a situation you will encounter in a civil law tradition. If you are representing your client in a particular case law, you may be in a good position even when you are citing the relevant statutory provisions or relevant provisions of a particular code. You don't have to read the statutory code in the background of a case law. In common law system, you have to do that. Suppose you are arguing your case under 73, you are claiming damages under Indian Contract Act, provisions of Indian Contract Act. So while claiming the damages as per the provisions of section 73 of Indian Contract Act, you in a common law system, you also have to argue your case keeping in mind the case laws, or keeping in mind the decided case laws. Suppose in a decided case law, the facts of which are similar to your terms of the contract, court gave a particular amount of damages, then you will cite that particular case law in front of the judge. That look, Mr. Judge, this and this, these were the facts of the case, and they are similar to my case, and the judge awarded so and so such and such amount of damages. So I should also be awarded a similar amount of damages. And this I am telling about lower court. When you go to the higher courts, for example, when you argue your case before the High Court and Supreme Court, then the entire structure has been created in such a manner that you cannot argue even a single paragraph without citing a case law. Your case is all about case laws.
So, like India follows the civil law tradition.
Yes. Dominant tradition in India is civil law tradition.
So in a red line, you have written under common law family, note this feature while studying the Indian Contract Act. So while prosecuting for any case under Indian Contract Act, we have to cite cases or not?
Yes, you cannot. That too you will realize yourself when you are why you are having this case material in your hand. Why not
So
a commentary written by a lawyer or a professor? Because the moment you are studying the provisions of the Contract Act, you realize that these provisions are incomplete without case laws. If I want to know the entire law, I need to read the case laws.
And on the other hand, we are saying that India is following the civil law tradition.
When I said this,
I'm asking you.
No. Just like now try to develop your ideas as if you are a lawyer. So what I am saying, for example, and what I will argue, I'll also teach you with the help of article, I will make an argument on the basis of that particular argument that the dominant feature of Indian legal system is common law. Dominant feature. But you may find traces of civil law tradition as well. So this statement is entirely different from stating that Indian legal system is a common law tradition ka system. No. In Indian legal system, if suppose you ask this question, that which tradition we follow in our Indian legal system, or Indian legal system is based on common law system or civil law tradition, then you will answer it smartly. You will say that, look, when I look at my system, then case laws form a core of the system. The decisions of the higher courts are binding on the lower courts. Judges are appointed from the practicing lawyers. Lawyers, being lawyer is treated to be a profession. Codes are to be read in the background of the case law. We conduct a trial by adversarial system, but we do not conduct a trial by jury, for example. Then you will say that it seems, keeping in mind these features, it seems that in Indian legal system, the dominant tradition is common law tradition. While on the other hand, in Indian legal system, we do have codes, or there are certain provisions of our statutes which are taken from civil law tradition. So there are certain kind of sprinkles of here and there of the civil law tradition as well. But the dominant system is common law tradition.
Are the statutes in the common law family different from the statutes under the civil law family?
This I have already discussed with you. I told you in civil law tradition, the way of drafting a statute or code is different. And in common law tradition, the way is different. I shared one example. For example, you do not find a definition clause in a civil law statute, or in a statute which is enacted by following the civil law tradition. You do not find a definition clause. And in every common law statute, you will find an elaborate definition clause. And there are other distinctions as well. So the dominant type of legislative enactments in civil law tradition are codes, and the dominant type or maximum number of legislative enactments in a civil law, in common law tradition, are statutes, acts. Rather, you should use the word acts, not codes.
Sir, I have a question.
बताइए.
Sir, in civil law system, there is a judicial hierarchy, as we have
Yes,
in India.
yes, everywhere. You cannot have a legal system without a hierarchy.
Sir, so if a person who is not satisfied with a judgment delivered in lower judiciary,
You can go to higher courts in appeal.
sir, so on what point they differ in higher court?
Points of
For
law,
example,
points of fact, it depends on what the system is. But
Sir,
there
you have
is-
said that in civil law system it is a closed system, which is basically based on general.
No. That closed system I used with the reference to the manner in which it is operated. Closed means that whatever be the facts of the case, you will apply the rules contained in the code. You cannot go into equity, natural justice, or all those aspects.
So basically, they differ on the basis of facts.
They may differ on the basis of law as well when it comes to applying the rule of law that is contained in the code to the facts of the case. ऐसा भी तो हो सकता है ना कि आपने गलत लॉ का इस्तेमाल कर दिया हो, गलत सेक्शन का प्रोविजन का इस्तेमाल कर दिया हो to decide a case.
Okay, sir. And one more question is there. Sir, in civil law system, it is not possible every time that a particular section or particular code circumscribe all the aspects of an offense. So in that case, if, for example, if a certain case comes and that case includes some new offenses, some new aspects of offenses, so they have to wait for a judicial scrutiny and all.
Amendment. Look, when an offense is committed, then it does not go to the court directly. First, a case is registered in both the systems. Police to exist in both the system, and they registered the case in a similar manner in both the system. So when an offense is committed, you register a case, and when you register a case, you will register the case under the provisions of a law. So that thing will be decided at that point only. You don't have to go to the court for that particular purpose. But your question, I will modify a little bit. Just a second, Ravi. Yes, no. Just give me 1 minute. I'll modify it a little bit. In common law system, judges enjoy this luxury that if they are confronted with certain facts which are not covered by the written law, which are not covered by statutory provisions, then they may infuse their own judicial mind into it and decide the case accordingly. But that is not possible in a civil law system.
Okay, sir.
The civil law system is something like this, where there is a law, there is a remedy. And common law system is that forget about law, where there is a right, there is a remedy.
Okay, sir. Thank you, sir. Got the point.
You find out the law. Like in common law system, the idea of the parties is my right is infringed. Now it is for you to find out the law. I need the remedy. And in civil law system is slightly different. It's like where there is a law. If there is a law in the code, then only I'll be able to give you remedy. So it's something like this. I would be really happy to help you, but I cannot do anything because nothing is written in this code. As administrative officers too, for example, if you go to a bureaucratic system or bureaucratic office, SDM office or DM office, and you want to claim some relief, so there you would hear this several times. कि लिखा ही नहीं हुआ है कहीं, मैं कहां से दे दूं आपको ये चीज?
Yes, sir. I heard.
अगर आप लिखा हुआ दिखा दो, मैं दे दूंगा ये चीज आपको. तो सिविल लॉ सिस्टम में जुडिशरी इसी तरीके से काम करती है, और कॉमन लॉ ट्रेडिशन में जुडिशरी ऐसे काम करती है. अच्छा देखते हैं, अच्छा पढ़ के देखते हैं, मे बी आई कुड डू समथिंग.
Yes, sir. I got the point now.
ठीक है. So we will meet tomorrow. You have a class now. So thank you so much.
Thank you so much, sir. Thank you so
We
much.
will continue. ये जो मैं आपको पढ़ा रहा हूँ ये बहुत इलैबोरेट है. अगर आप इसका 50% भी ध्यान में रख लोगे, ये एक्सट्रीमली इलैबोरेट है, ये काफी इलैबोरेट है. ठीक है. तो
एक डाउट था.
हाँ जी बोलिए.
सर ये जो जैसे आप बोले कल स्टेट डिसाइजर्स का कोई रोल नहीं रहता सिविल लॉ में, तो सर जैसे हायर कोर्ट ने कुछ नई सिचुएशन अराइज हुई और उसने ऑफेंस डिक्लेयर कर दिया और पनिशमेंट
इतना लीव एंजॉय नहीं करते हैं वहां के हायर कोर्ट्स को. इंडिया वालों की तरह नहीं है कि विशाखा केस आ गया और हमने अपनी मर्जी से डिसाइड कर दिया और पेगासस की जांच भी हम ही करेंगे और फार्मर्स प्रोटेस्ट ठीक है गलत है ये भी हम ही डिसाइड करेंगे. ऐसा सिस्टम नहीं है. इट्स अ डिफरेंट काइंड ऑफ अ सिस्टम.
ओके सर. सर मतलब लोअर कोर्ट का भी उसमें नहीं रहता है उतना.
हायर कोर्ट में भी दे गो बाय द लॉ. लोअर कोर्ट तो बिल्कुल ही बेचारे एसडीएम की तरह बिहेव करते हैं, बट जो हायर कोर्ट है वो भी दे गो बाय द वर्ड्स ऑफ द लॉ.
ओके सर. यस.
अब वो कॉम्प्रिहेंसिव है ना. मैं आपको एक बेसिक आइडिया दे रहा हूं. अब हो सकता है मैं गलत भी हूं, बिकॉज France has a civil law system, Germany has a civil law system, Portugal has a civil law system, all Scandinavian countries have civil law system, most of the Latin American countries have a civil law system, Japan has a civil law system, Russia by and large nowadays after the disintegration of USSR has once again have a civil law system. तो मैं कहीं पे थोड़ा बहुत गलत भी हो सकता हूँ, but this is the larger picture, main feature, because we are not discussing a particular system. So therefore we cannot be exact in every point. We are discussing the main features of a system. So it's a more a theoretical discussion which may have some practical linking. जैसे कि मैंने आपको बताया कि in adversarial system there is trial by jury, but then you can raise your hand and say but in India we do not have a trial by jury. But that is true. But that does not make India to be a civil law country, because other features are there in our system which we have taken from common law tradition. Thank you so much. We will meet tomorrow as scheduled, and we will discuss, we will complete this topic by discussing socialist family of laws and giving brief comments on other Eastern traditions of law.
Okay, thank you, sir.
Thank you, sir.
Thank you.
Thank you, sir.